This video is all about why you can't give assets to a minor when you pass away. Now think about this. All the time we have people who come to our office and they say so-and-so's passed away and they listed their daughter or granddaughter or niece as a beneficiary under their life insurance policy or on their bank account. But that evil financial institution, that evil life insurance company won't give me access to the minor's share of that account. And of course, we have to be the bad guy and explain, you know what, that financial institution, that life insurance company isn't so evil. They're actually following the law. And actually, you're not allowed to give a large inheritance to a minor. And you would think, well, why not? I mean, shouldn't they be able to receive their inheritance just the same as anyone else? Well, in most states' laws, minors have little rights in terms of being able to contract or being able to receive an inheritance. And most states have adopted a law that says transfers to minors are impermissible if it's over a certain amount. So that transfer to a minor, maybe if it's less than $10,000 or $15,000 or $20,000 is okay. But if you go over that threshold amount, like in a life insurance designation, that's an unlawful transfer to minor, and the life insurance company is actually correct in not giving that minor her share until she's 18. So if you were thinking about leaving a minor beneficiary on your life insurance or your bank account designation or in your will, stop. Don't do it. Most states' laws will say that's actually unlawful. And the life insurance company or whomever isn't a bad guy for refusing to give that minor their share because it would be unlawful for them to give that share. But even though it might be unlawful to leave a minor as a direct beneficiary, we have our tricks. We have ways that we can do this. So a lot of times when we have a client that says, you know what, Isaac, if I pass away, I've got a minor child that may be a beneficiary on my policies, I'll say, whoa, time out. We need to handle this carefully. And the way we typically do that is through some sort of trust. Now, I know you're thinking a trust is complicated or that's only for rich people, but hear me out. If you have a will with a little bit, like a half-page trust that says, look, if I pass away and there's a potential beneficiary under the age of 18 or even 21 or 25, I don't want that young beneficiary to get her share outright. Instead, I want her to get her share through a simple trust where there's a responsible adult over that share. Now, if you have just a basic trust set up in your will like that, in your beneficiary designation, whether that's in the will or whether that's a life insurance policy or a bank account beneficiary designation, if you point to that trust, that's legal. Because then the minor didn't get her share outright. No, it went into a trust where she was a beneficiary. And there was an adult, someone of age, who is in charge of managing that share for that minor beneficiary. So the minor beneficiary can get it, but just not directly. And let me level with you for a second. I think it kind of makes sense that our laws say that minors can't get large sums of money outright. I have seen so many young beneficiaries blow inheritances. So when we set up these contingent trusts inside wills for clients, a lot of times we'll say, well, client, look, the minimum age for that trust is age 18. But are you sure you want to give an 18-year-old direct access to $100,000? I mean, do you remember what you were like when you were 18? No. We should make that trust termination age something like 21 or 25 or even 30 years old. That way, if you pass away and that beneficiary is under that age, there'll be a responsible adult to manage that life insurance money or to manage that will inheritance so that it doesn't get squandered by a know-it-all teenager. I'll give you a quick example. Years ago, I handled this case where there was a young heir to an estate. Now, he technically was 18, and like so many 18-year-old young guys, he thought he had it all figured out. And I asked him what he was going to do with this large inheritance he had just received, and he said, Isaac, I'm an entrepreneur. I got it all figured out. What I'm going to do is buy a bunch of used cars and create a used car lot, and I'm going to be rich. And I thought, this guy doesn't know anything about running a business. He doesn't know anything about the used car business. I'm really afraid this guy's going to blow it all. So I asked him if he was sure. I asked if he might be willing to speak with a CPA or a financial advisor to help him manage the money, but he was resolute in his 18-year-old wisdom. He was going to get rich selling used cars. Well, you know how this story goes. The money didn't last. When I talked to his uncle a year later, sure enough, the young man had lost all the money in his failed used car business venture. So even though this guy didn't have a drug problem and wasn't an idiot, he basically didn't have a lot of money experience and not a lot of wisdom. And I'm sure that same guy as a 25-year-old would have handled the money way differently. So, to boil it down, you can't have a direct minor beneficiary on your life insurance, on your bank account designations, or on your will if that money that minor person would potentially get upon your passing is over a certain threshold, which in most states is $10,000, $15,000, or $20,000. That would be an unlawful transfer to a minor. But you can get around that problem by having even a basic will with a basic trust set up in that will. I hope you found this video helpful.